Marco. As Marco said, I'm Adam Mambi. I'm working with the Tanzania Communication Regulatory Authority as a senior legal officer. I've also been teaching at the University of Dar es Salaam the subjects of cyber law, intellectual property law, and competition law. As you can see from the program, my discussion is focusing on the legal issues. What are the legal measures as far as children protection are concerned? If you look at the structure of my presentation, I have divided my presentation in the following parts. First of all, we'll be looking at the legal implications of digital technology. What are the issues? What is the impact of ICT to children? We'll also be looking at the e-children pornography under the digital era, which has been mentioned by my colleagues. What is the scope of the problem? We can look at some of the data. What are the dangers our children face when they are involved online? Who are the exploiters? Who are the predators? We need to know them. How to identify these offenders? We can also have practical case study on e-identification problem. There is a problem with identification. What are the legal issues? Are there any judicial responses or cases? What's the role of intermediaries, ISP, OSPs? What's the legal basis for intermediaries' liability? So there are so many issues like how to draft the laws, why cyber laws might lack enforceability. We'll see the reason. And then we can also consider the existing international legal instruments that deal with child protection. What are the legal challenges on jurisdiction problem when we are trying to enforce these laws? A little bit on electronic evidence and the suggested solutions. So those are the areas, if we'll have enough time. If you don't have enough time, tomorrow we'll have the same discussion. When we talk of internet governance, we should not forget these issues. You can see those are the issues that we need to consider. You are talking of e-commerce, cyber crimes, e-security, data protection, child grooming, cyber stalking, e-identification. We're also talking of e-gambling, e-jurisdiction problem. Those are the things to take in our minds. But let me go straight forward to my presentation. I'm just trying to look at the implication of ICT to our children. What is technology doing? I think we are all aware that technology or digital technology has facilitated the recording, transmission and storing of images and text on digital media. I think this is obvious. People are just uploading, people are just downloading these kind of images. So that's obvious, we all know. If you look at what ICT is doing to our children, ICT is trying to make children to learn, play, and communicate. They can learn, they can play, they can communicate. But internet plays a major role in child sexual exploitation. So it's trying to play the major role when you talk of child sexual exploitation. And this is done through whereby you find that internet can enable offenders to target children, individual or collectively. That's what is happening. Internet is used to distribute homemade and commercial child pornography. Think about peer-to-peer networks. That's what ICT is doing to our children. And obviously, young person or children, these are the most vulnerable of these illegal activities. They are always at risk. They can be harmed by child pornography, by being exposed to child pornography, or they are being filmed electronically. If you look at some of the data from various sources, you can see FBI is saying that over 50% of all child pornography says in the US indicates boys rather than girls. I'm not sure if this is true. I just found it on the internet. If you look at Canadian custom, they are saying 75%. That's found in Canada. Of course, if you look in early 1970s, Denmark, Holland were the main centers of production in Europe. Germany, UK followed by that time. Just if you look at just that that figure, you find that 44% is child pornography. So it's the largest image production electronica. This is child pornography compared to adult pornography. That's a source from US General Accounting Office. You can also see the dangers that children face online. These are the dangers. They can be exposed to inappropriate and harmful materials such as obscene, drugs, and alcohol. So those are the dangers children that can face. You have so many dangers you can read on your own. These are normal dangers. Cyber, you have sexual solicitation, you have hate speech, you have cyber stalking, you have e-defamation, you have cyberbullying. Those are the dangers that can be faced by our children online. But do we have legal measures or laws to cater for this child e-abuse? That's the question I'm posing there. If you look at those dangers, you have the laws. We need to consider on that. Again, what's the legal definition of a child and child pornography? I think this has been discussed by one of my colleagues. That if you look at the definition of a child itself, laws, national laws and international conventions, we find there is a difference. The definition varies. Others are saying it's under 16, others are saying it's under 18, others under 13. But of course, if you look at the international conventions, it's under 18. So there is that difference. Again, the word child pornography has been differently defined, as my colleague said. So if you have those differences in terms of definition, then you might have problem. If you look at Canadian Penal Code, the Canadian law, they say that a minor for child pornography is just a person under 18 years. So that's the definition. There are so many laws. You can look at your own time at the way they have defined child pornography. For instance, the U.S. Child Pornography Prevention Act, their definition goes further by saying that is any child pornography which is produced by enemies. I have underlined the word enemies, whether it's physical or e. So that definition is covered. There is also the definition of EU Convention for Cybercrime, 2001. You'll see the child is a person under 18 years of age. So you have such kind of differences. If you look at Commonwealth, we have Commonwealth model laws. That was the bill on computer and computer-related crimes. They also have the definition of child pornography. So you can read that on your own. But more important, that model law defines the word publish. It's very important to define the word publish so that it can cover e-publication. As you can see, the way the model law has defined the word publish. Again, who are the offenders of our children? Or who are the offenders of our children electronically? These are the offenders. The producers, middlemen, distributors, sex tourists, and those the other offenders. I'm not sure if you are the consumers or the producers of this kind of illegal images. But again, how to identify these offenders is always a problem. The question of anonymity under cyberspace. Identifying these offenders or children who are being affected, because there is one saying in the internet environment that in the internet or cyberspace Nobody knows you are a dog. You don't know with whom are you communicating. He might be a dog or something else. So it's somehow very difficult to identify from some of the sources. In one case, a 12-year-old boy planned a meeting with what he thought was an 11-year-old girl. Instead, an adult male showed up and told the boy that he was the father of the 11-year-old girl and that she would be waiting at home. Once in the apartment of the adult male, the boy was forced to look at child pornography pictures before he was able to escape. So you can see what is happening in the internet as far as our children are concerned. That's the problem of identifying the offenders. But let's consider the following illegal issues. If you want really to regulate internet and protect our children, how can we make cyber world a safe place for young people to work, learn, and play? How can we create a safe and secure online experience for children everywhere? We have to protect our children against cyber threats targeted to children. This was the statement by UN Secretary Gen Ban Ki-moon. Do we need for effective e-legal framework at national, regional, or international level? Do we need that? I think the answer is yes. The majority will agree with me. Is there any global consensus on content regulation, obscenity, and indecency? Is there any global consensus? The answer is no. I think you have heard from the presentation. In some countries, obscene materials is legal. In other countries, it's illegal. So there is no global consensus. So we need to have a global consensus, specifically on children. What type of content should be considered obscene or indecent? What type of content? Is there any international agreement on the age of sexual consent? Do we need to have standards and rules for determination? Because it varies. Standard and rules for determination is always vary in all countries. Let's look at the sum of the judicial responses. There is this case. I'll just read it very fast. This is the case of 1997. It's found under all England law reports. In this case, the appellant working at the Birmingham University using university computer linked compiled a large database of pornographic images of children. He did it without the consent of the university. The first case, the word internet to appear in the judgment. But the conduct occurred before the enactment of the 1994 Act. What was the issue? Whether the images stored on a computer disk could be classed as photographs. That was the issue in this case. So you can also read those cases below. You can read on your own time and see what are the issues that were discussed by the court as far as children pornographs are concerned. Again, our colleagues mentioned about ISPs, that is intermediaries. What's the role do they play? The role they play as far as children protection are concerned. It is obvious that ISP play a big role on computer users to access materials online. I think that's the fact, because they facilitate access to materials on the internet and gain financial. They facilitate, but at the same time they gain financial because people are paying to get access. But at the same time, ISP are under the risk of liability if they host a website displaying obscene materials. But what will be the legal basis for intermediaries liability? How can we put ISP liable? What are the legal bases? If you really want to say that one ISP is liable due to the fact that they are facilitating the transmission of these illegal images that harm our children. First of all, should we base on knowledge? If you look at some of the laws, they always base on knowledge. They can only be liable if they have the knowledge about that illegal materials. But should we all base on that that component? That should be the question of knowledge. That's one. How about possession or transmission? Should it make them liable when they possess or transmit? It might be difficult if you just say possession. Intention to distribute, whether they have intention to distribute those illegal images. What acts that can be committed by ISP to make them liable? We have to think about those acts. Where are these acts committed? As we know that there is no boundary when we talk of cyberspace. But we have to come up with the issues on how to identify where are these acts committed by ISP. Should we grant ISPs some limited immunity from liability for third-party content? Should we grant them some limited immunity? Some of the laws provide that. But here we want to come up with the international position. Again, how can we draft laws to criminalize intermediaries? How can we draft law to make ISP or intermediaries liable? You can look at the knowledge, possession, transmission, distribution for gain. That's what I mentioned earlier. But you can look at the sum of the laws as a references. There is one law known as Tennessee Code, that's from US. You can look at the UK Obscene Publication Act of 1959, which was amended in 1994 to take into account the legal implication of ICT. UK Telecommunication Act of 1994, German Multimedia Law of 1997. You can just have a look on those laws. But again, you have those cases as far as ISP are concerned, whether they are liable, if they are liable, how to put them liable. You can read those cases on your own time. But what are the legal measures when we talk of child e-pornography? What are the legal measures? Do we need laws or regulations? We have to think. Do we need laws or regulations? If yes, will they be effectively enforceable under cyberspace environment? Those are the crucial questions to be asked when we are thinking about regulating internet or content. If no, how can we assure e-security, e-threat, and privacy? If no, we have to consider about e-law applicability, not an issue, but the issue is enforceability. The application of law is it's not really issue under the cyberspace, but the real issue is how to enforce these laws. Should we go for self-regulation? Someone says the use of sticks and carrots. Instead of having the laws, should you go for self-regulation? We have some examples of self-regulation schemes whereby members agree to abide by the scheme's rules, but these are not binding. Anyway, we have some examples of self-regulation schemes. These are the examples. In some countries, these regulation schemes are recognized by the law. For instance, in Australia and in Germany, these self-regulation schemes are recognized by the law. But why cyber laws might lack enforceability? When we talk of cyber laws, when we are drafting cyber laws, we have to consider these issues. These are the key issues. Otherwise, your laws will lack enforceability. First of all, if your law is based on single jurisdiction or application, that is trans-jurisdiction nature of cyberspace, then it might lack enforceability. You have the law which applies only in one country, does not apply in another country, and as we know that there is no boundary when you talk of internet, then your law might not be enforceable. You also have the lack of court's jurisdiction. If the court in India does not have jurisdiction over the act which was committed from Australia or from Europe, then your laws lacks enforceability. There is also lack of prosecution jurisdiction. If you have prosecution who lacks jurisdiction, then you have the problem. Variations in criminalization. This was mentioned by my colleague, Mr. Carr. You might find sometimes lawful conduct, but unlawful in another jurisdiction. In one country is lawful, in another one is unlawful. You have these two different laws. Then your law might lack enforceability. It can't be enforceable. Again, if you have the law whose course of enforcement outweighs the benefit of enforcement. If the cost of enforcement outweighs the benefit of enforcement, then you have the problem in that law. How about the question of unconstitutionality? Some might challenge the laws basing on the Constitution, that it is unconstitutional. We're talking of freedom of speech. So that's also a problem. If you rely too much on extradition treaties, I think we are aware of extradition treaties. That is one country is making an agreement with another country. They have a treaty that in case of any offense committed in both countries, someone can be extradited. But if you rely too much on these things, you might find that in one country, the offense, I mean, that is illegal, in another country is not illegal. And that must be provided under the treaty. So those are the reasons why cyber laws can lack enforceability. Are there any legal response to child pornography? We have some laws. If you look at as various countries, we have some laws, of course, but again, these legal measures are designed vary among the countries. And most of the laws were started, I mean, most of these laws were enacted in 1970s. For instance, in US, you have that laws. In Taiwan, they passed the law in 1995, which shows electronic signals, so this law even applied to cyberspace. Australia, they also have the law. You have those kind of examples of laws. There are so many laws that touch on child protection. England, UK, they have these laws. And you can find, for instance, these laws mention about the computer disk or other electronic means. So at least we have some laws from other countries. Again, Criminal Justice and Public Code of 1994, which say include data stored on a computer disk or by other electronic means. So at least you can see some of the examples of laws which can cover children protection online. So we have so many laws. We cannot discuss all of these laws. You can read on your own time. Just examples of national laws. But now let's look at international level. Do you have any international legal instrument as far as children protection is concerned? We have this convention, I think we are all aware, Convention on the Right of the Child, that was passed in 1989. Of course, there are so many provisions which protect children, but I'm not sure if this law or if this convention really capture the internet environment. Does it capture the internet environment? Because it was passed in 1989 and the technology is changing very fast. So we need to take into account on this convention or this treaty. So you can read on your own time this provision, these are the relevant provisions which protect children. And articles, you can read articles 16, 17. They're always talking about children protection, the importance of nations making laws that will protect children. So we have so many conventions. We also have the ILO Convention number 82. Somehow also mention about child protection. But at regional level, you have Council of Europe Convention on Cybercrime, which was passed in 2001. At least this convention covers a lot of issues related to cyberspace. For instance, if you read Article 9, addresses the problem of child pornography, that is content-related offenses. If you read Article 9. But the convention also empowers searches and interception of materials on computer networks. So at regional level, you have that convention, but you can just consider some of the issues when making your laws. You can see whether they are relevant at your national level or international level. So there are so many offenses that are committed, that are provided under this convention as far as children are concerned. For instance, this convention mentions about producing, offering, distribution or transmission, procuring, even possession of child pornography. That's an offense under this convention. So you can read on your own time if you have time. What is criminalized by this?
Convention, those are the issues that are criminalized. Production, offering, distribution, and possession of child pornography, electronically. But I found also there is another Council of Europe Convention on the Protection of Children Against Sexual Exploitation and Abuse of 2007. I just found it in the internet. I don't know if this is already in force, but it's up to us to think and come up with what are the legal issues that are addressed by this convention as far as children protection is concerned, electronically. Again, this convention also have preventive measures, principles, for instance, Article 4, Article 6, 11, and 14. Quite cover about children protection online. There are so many articles that you can read on your own time. There's also this Declaration of the Rights of the Child of 1959. This is a UN declaration that can also be considered when trying to come up with an international legal framework for cybersecurity. At Commonwealth, they also have Commonwealth model law. If you read Article 10, it's very clear on child protection online. The one who publishes, the one who produces, the one who possesses. And again here, child is also defined. And child pornography is defined under this model law. So we can read all these legal instruments and come up with common sense, come up with common legal issues. But there is the question of freedom of expression under Convention on the Rights of Children, 1989. If you want to regulate the internet, other people will say, okay, there is the question of freedom of expression, freedom of speech. Does that hamper our aim of regulating internet so that we can protect our children? But of course, when you have human rights, it's not absolute. These rights are not absolute. They have to be subjected to other laws. So this cannot limit us in coming up with legal framework to protect children online. When I was reading this international legal instrument, or when you read, you might come up with the conflicting international issues. Which one supersedes the other? You have these kind of conventions at international level and regional level. You might come up with conflicting issues. What are those issues? Some might ask, is it unconstitutional? How to balance the rights in Article 19, that is freedom of expression and the right to privacy of the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights, European Convention for Human Rights, and the right of children under Convention of Rights, Convention for Children's Rights. So we need to balance these issues. Should we apply limitation principles? I think we should apply limitation principles. Freedom of speech must have limitation because there is no absolute right. Those were my opinions. But of course, we have other measures which has been mentioned by my colleagues, that is technological measures, hotline and code of conduct. You can use bilateral agreements, or you can establish online content regulatory authorities and community awareness. Those are the other measures apart from legal. So you have so many measures. We can make all offenses extraditable. That any offense which is committed electronically should be extraditable. We need to have uniform legislation on e-content. We can also try to see whether we can enforce the existing laws we have. We need for concerted international efforts to combat transnational traffic in child pornography. So those are the things that we can do. Of course, we have other international initiatives, that's legal measures by ITU, supports the global cybersecurity agenda. This is the ITU agenda, which says we need to have an international framework with 5 main aspects. Those are the 5 main aspects that are addressed by ITU. Legal measures, technical and procedural measures, organizational structure, capacity building, international cooperation. So we can think about that. There are so many legal challenges, but just to highlight some of our other legal challenges are the question of jurisdiction. Because when we talk of cyberspace, there is no sovereignty or territorial limitation. We need to think about these legal issues. Materials can be placed on a server anywhere and accessed anywhere else. This kind of illegal materials. Materials might be lawful somewhere but unlawful somewhere else where it is accessed. So we have to think about those issues. Which legal system will apply in that case? That's why we are saying we need to have a common consensus when trying to criminalize these illegal activities. Which court will have jurisdiction? We have to think about that. Otherwise, you cannot enforce such kind of instrument. Where does publication take place? Which country has the right to arrest e-crime offenders and prosecute under the cyberspace? This has been discussed by Mokolish. So what we are saying that individual countries cannot legislate over internet content because that content is either located in or elsewhere and easily shifted to foreign jurisdiction. So it's very difficult for individual country to legislate all issues. So maybe we need to come up with an international legal instrument which will cut across, and all partner states should be bound to make national laws that comply to that international. Read the cases. There are some cases which have addressed the problem of jurisdiction when we are trying to enforce these kind of laws. You have this famous case, that's Yahoo case. You can read on your own time, whereby the website was located in the US, but French were complaining about illegal images that were being displayed in French. The question was whether French court had jurisdiction to entertain this case. This is very interesting, so you can read on your own time. These are the other cases, if you have time, you can read from the websites on each jurisdiction problem and how to solve this kind of problem. We have so many cases. But the other legal challenge is the question of electronic evidence. In most countries, electronic evidence is not admissible, while in other countries, electronic evidence is admissible. So if electronic evidence is not admissible, then that's a problem. Because some countries, they rely on base evidence rule that the evidence must be original. And then when you say, if you have computer printouts, that is not admissible because it's a copy. The original has been left out in your computer system. So we also need to think about the question of admissibility of electronic evidence. Do you have some suggested solution? I was suggesting the following. Let's use functional equivalence between paper-based requirements and digital technology. We have offline laws, and then we have e-laws. We can use functional equivalence, where the law requires to produce, let's say, base evidence rule or original evidence, then that requirement can be met by e-evidence. That's just an example. We can also think about the other convention I mentioned about Council of European Convention on Cybercrime. You can think, which is optional. And we need to enact uniform e-laws or cyber laws, bilateral agreements, extradition treaties, prepare e-conventions, e-treaties at international level under the UN. May I conclude my presentation by the following message from ITU. That's a message from ITU I got from their website. Be careful who you speak to. Be careful where you go. What is true offline is unfortunately also true online. What they are saying at ITU, we believe that children everywhere have the right to a safe environment, even when that environment is a cyber one. You get that message? Again, while the connection might be virtual, the danger is real when they were launching COP. So that's a last message from ITU. And that's end my presentation. Thank you very much.